Hi there, Martin from Salvo Migration, and in this video I'm going to explain what the difference is between being in a de facto relationship, an engaged or fiancé relationship, and a married relationship, and a civil union. What's the difference? What does one mean versus the other, especially when it comes to applying for an Australian partner visa? So stick around. Welcome back. So this video may look a little bit different to the others that you have seen on our YouTube channel because around me you might see a background image, which is actually a page taken from a very new resource that is becoming available to the public. It's called the Secret Most Important Documents for Any Australian Partner Visa Guide and Checklist. And this is actually one of the pages inside the guide, which is 100% free. Around this video, there should be a link to go and get yourself your copy. But in this video, I wanted to walk you through some of the key topics and concepts that we do talk about more in the guide, which by the way, comes with a bonus video training. So I thought this video might be useful to give you a bit of a glimpse inside what is inside the actual guide. Now, to the point of this video, now let me just see if I can reduce my face a little bit. When it comes to partner visa options to Australia, that's always the best starting point, is understanding that there really is 3 partner visa options for partners or spouses of Australians. The partner visa that works best in your case will primarily depend on where the visa applicant is or where the visa applicant intends to be when the application is submitted. If the loved one, if the visa applicant is overseas, there's 2 visa options that might be available. There's the subclass 309 or 100, which is a combined application for what we would call the full partner visa options, or there is the prospective marriage visa option, which is for couples that are engaged that maybe do not qualify or meet the criteria to apply directly for the 309 100, the full partner visa. So the PMV often is what we would call a half visa, in the sense that it is granted on the basis of a couple intending to marry, coming onshore, and then applying for the onshore partner visa, which is the subclass 820-001. That is a combined application, and it more or less mirrors the requirements of the offshore 309-100. So again, to reiterate, if you're inside Australia or the applicant is inside Australia, or you plan for the applicant to come onshore and apply for an onshore partner visa, you'll be looking to apply for an onshore 820-001. Whereas if you're offshore, you're either weighing up the options of the 309-100 or the prospective marriage visa. Now, in terms of the requirements for these visas, when we're looking at the 309-100 or the 820-001, in simple terms, at the time that those visas are submitted, couples need to be able to demonstrate that they are in a de facto or spousal relationship. Okay, so that's, I suppose, the first 2 definitions that we're comparing. What does it mean to apply as a de facto couple versus what does it mean to apply as a married couple, as a spousal or a spouse-based relationship? In actual fact, when a case officer is assessing couples against those definitions, they're really looking at the same thing or the same things. And what they're looking at are the 4 main areas of the relationship: the household and cohabitation, so how a couple live together; the financial aspects of the relationship, how they pool their finances to preferably pay for their living arrangements; the social aspects of their relationship, in the sense of, do the couple's social circle, their friends and family, their immediate circle, know about the relationship? Are they aware, and do they think that the couple is in a married or spousal relationship? And then the nature of the commitment that the couple have to one another. How long have they been together for? How long have they lived together for, if at all? How long have they been pulling their finances together for? What do they list as their plans as a couple? Do they plan to get married? Do they plan to have children? Do they plan to travel together? What have they expressed in their relationship statements in terms of their future plans as a couple? And really, in short, what a case officer will do is look at all 4 aspects, but most importantly, the documentation that's provided to evidence those 4 aspects. Because there's one thing to say certain things in your application, or to claim things, but it's another to prove them with your documentation and relationship evidence. So the case officer goes off the evidence, not what you're saying necessarily. So they look at the evidence against all 4 aspects, and they make a determination on the balance when this visa was applied for and when it's being assessed when this picked up, are the couple and were they in a de facto relationship or in a spousal relationship, or neither? Were they just boyfriend, girlfriend, boyfriend, boyfriend, or girlfriend, girlfriend, in the sense of the 4 aspects just didn't satisfy a case officer that this couple really were committed, that they were short-term in length, weren't really pulling their finances, their friends and family provided weak supporting statements, and they've only maybe been living together for a very short period of time when the visa was applied for. Therefore, the case officer can use their discretion, their judgment, to determine that this couple maybe wasn't really in a de facto or spousal relationship. Now, just to clarify here, getting married doesn't mean that you're going to be able to demonstrate to the department that you are living like a married couple, that you are living like a spousal couple does. And that is why I always say getting married or a marriage certificate doesn't equate to a partner visa being granted. You still need to satisfy the 4 aspects, just like a de facto couple does. So de facto or spousal couples still need to evidence the 4 aspects of the relationship. The marriage certificate helps to strengthen the application to some degree, but it doesn't automate or automatically lead to an approval of a partner visa. Looking at the prospective marriage visa, there's no legal requirement that a couple are in a de facto relationship or that they are in a married relationship. The requirement is that they have met in person, that they intend to marry, and that they intend to live together as a spousal couple once the prospective marriage visa is granted and the visa holder is able to enter Australia and then apply for an onshore partner visa. So when we're preparing prospective marriage visas for our couples, our clients, we are evidencing the couple's wedding planning, but we are also still evidencing the 4 aspects of the relationship. So it's a bit of a misconception that couples applying for a prospective marriage visa don't need to provide documentation that ties into the 4 aspects. That is unfortunately incorrect, because you do need to prove that you intend to live together as a spousal couple later, which is where they look at the 4 aspects. So arguably, couples applying for a PMV have to provide more than couples applying for the 820, 801 or the 309, 100, in the sense that it's not just about your wedding plans, it's about proving that you will live together in future as a spousal couple. So therefore, when it comes to prospective marriage visa applicants, generally the relationship status will be engaged. You are the fiance of an Australian citizen or permanent resident, so your relationship status is engaged. Versus those that are applying for the 820, 801 or the 309, 100, at the time of application for those visas, couples will need to demonstrate that they're in a de facto relationship or in a married relationship. So this is where we start to compare the differences in terms of what it means to be de facto versus married versus engaged when weighing up which visa option may suit any particular couple. So really, to recap, when we're looking at what is required for these visas, first of all, let's start off by asking, where is the visa applicant, or where will the visa applicant be when they intend to apply for a partner visa? That will determine the partner visa options available. If offshore, if overseas, you're looking at applying for a 309, 100 or a prospective marriage visa. If you're onshore, you're looking at applying for a subclass 820, 801. What you must prove for those visas varies. For those applying for a 309, 100, you need to demonstrate you're in a de facto or spousal relationship. There is another pathway, which I won't go into too much detail in this video, which is where you can actually apply on the basis of intending to marry, just like you do for a prospective marriage visa. The scope of this video does not cover that, let's say, different pathway, but just understand that it is an option, and mainly that falls into the situation where someone will actually apply for a prospective marriage visa. So they're overseas, they're engaged with their Australian partner. They don't feel that they meet the requirements for the 309 when they're looking to apply. So they apply for the PMV on the basis that they will marry in future. Then, for whatever reason, plans change and the Australian citizen leaves Australia, often to be reunited with the visa applicant, and they get married. So the PMV is processing, it's pending. The couple actually get married whilst the visa is processing. In that instance, they convert the prospective marriage visa to a 309, and then the application is assessed differently. The 309 application is assessed differently. At the time of application, they're assessed against that they had an intent to marry, and at the time of decision, they're assessed against whether or not at that point they're in a spousal relationship, because they're then married. There's no way to get a prospective marriage visa granted to someone that marries whilst the visa is processing. It must be converted to a 309. The process is relatively straightforward and simple. There really shouldn't be too many complications, but just understand that it does change how a relationship is assessed. For those applying for 820, 801, what you must prove is that you are in a de facto or spousal relationship at the time of application and at the time of decision. The areas of the relationship that they will assess, basically across the board, they're going to look at the 4 aspects of the relationship. The importance or the significance of those 4 aspects will vary slightly depending on the visa you're applying for. We would say that the 309 and the 820 are more or less the same in the sense that they are fundamental to proving that you are in a de facto or spousal relationship. Whereas for a prospective marriage visa, I would say they're secondary. The primary requirement is that you intend to marry, but you still want to try to evidence the 4 aspects to the best of your ability. And that, guys, wraps up this video, which is where we've compared what it means to be de facto, spousal, fiance, intend to marry, and where those definitions fall into the partner visa options. Just again to reiterate, all the diagrams you've seen me walk through in this video have been taken from our free resource, the most important documents in any Australian partner visa guide and checklist. There's another 20 pages worth of diagrams and infographics in that free guide. And it does come with a bonus 30-minute video training, which is like this, where I'm walking you through the other pages to give you a complete in-depth understanding, a breakdown of what is required of anyone applying for an Australian partner visa, irrespective of the 3 varying options that may be available to you and your partner. Again, Martin from Salvo Migration, and I'll see you guys in the next video.